Welcome. Today we're going to discuss an opinion made by the Trademark Trial and Appeal Board in STX Financing versus Stacey Michelle Terrazas. My name is Scott.Slavick. I'm the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. In this case, STX Financing, producer of the film Bad Moms, filed a motion to strike the exhibits listed in the applicant's notice of reliance to the TTAB to oppose the registration of the marks Bad Moms Unlimited and Bad Moms Bible for audiobooks, printed matter, clothing, and charitable foundation services. A notice of reliance is essentially a cover sheet for the materials sought to be introduced. As the title suggests, the notice of reliance serves to notify opposing parties that the offering party intends to rely on the materials submitted thereunder in support of its case. A party needs not disclose the evidence it intends to submit under notice of reliance in its pretrial disclosures. STX achieved little from its all-out attack, but did give the TTAB the opportunity to clarify or explain several issues concerning the submission of internet evidence. The applicant's notice of reliance contained the following items. 1, copies of third-party registrations and applications obtained from the test database. 2, selected pages from the file history of opposer STX's pleaded pending applications obtained from the TSDR database. 3, screenshots of various websites. And 4, STX's response to applicants' interrogatories. The board granted STX's motion only to the extent of requiring the applicant to indicate the relevance of items 1 and 4. The applicant had stated only this, quote, to show no likelihood of confusion and/or dilution, end quote. That was too broad according to the board, because a party must associate each exhibit with a specific fact or a particular element of the claim of likelihood of confusion or dilution. The board allowed the applicant 15 days to file and serve an amended notice of reliance. As to the first item, the board pointed out that copies of third-party registrations are admissible under a notice of reliance as official records. STX had argued that because the copies submitted by the applicant were obtained via the internet, they must include the date and material was accessed and printed and the source. Not so, said the board. Since these printouts are admissible as official records, it was not necessary for the applicant to provide the access date or URL for any of the third-party applications or registrations. The applicant clearly provided a copy of the records obtained from tests, which is all that is required. Since pages from the file history are official records, they are self-authenticating and admissible by way of notice of reliance according to the board. STX complained that the applicant did not submit entire office actions, but the board noted there is no requirement that the entire file history be submitted. STX went so far as to gripe about a typographical error in the applicant's identification of the serial number of one of the file histories. The board pointed out, however, that the correct serial number was apparent from a review of the exhibit. Each of the applicant's internet exhibits included the URL for the specific page of the exhibit, but did not include the date the web pages were accessed or printed. However, that information was provided on the accompanying notice of reliance. STX contended that this information must appear on the face of the documents for purposes of admissibility. Wrong again. Internet materials are admissible so long as the date the internet materials were accessed and their source, for example, URL, are provided. The rule does not require that the date or source information appear on the document themselves, but only that the information be provided. If the access date and source are identified clearly in the notice of reliance, the web pages are in compliance with the board's rules. STX also argued that complete copies of the website documents must be submitted, but the board disagreed again. The board's rule states that internet materials may be submitted in the same manner as a printed publication in general circulations, and that a printed publication or a copy of the relevant portion thereof may be submitted under a notice of reliance. STX pointed to a different rule that stated that the submitting party must ensure the completeness of the evidence submitted. The board pointed out, however, that rule was not a rule, but a resource and guide, but does not modify, amend, or serve as a substitute for any existing statutes, rules, or decisional law, and is not binding upon the board. Moreover, the board stated that STX misconstrued the rule anyway, which points out merely that the submitting party must ensure that the entire exhibit is uploaded and not that each exhibit must be a complete copy. STX's only objection to the applicant's submission of STX's interrogatory answers concerned the failure to properly identify their relevance, as discussed above, to the extent the motion was granted. And so the end result of STX's motion was little more than delaying the resolution of this proceeding by 6 months. The real question is, would you have moved if you were STX? Sometimes clients want to file motions, even if they don't think they'll win, in order to show the other side that the client's going to fight everything to increase costs on the other side and to in turn gain settlement leverage. The downside to doing that is that it increases the cost to the client as well. And if ultimately the case has to be decided on the merits, the client might have pushed the fact finder against the client. Filing motions is a very strategic decision. Sometimes it's better not to file than to file to drive up costs. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.